All right, good afternoon, everyone, and thank you for joining us for today's American Ambulance Association webinar on workforce compliance during the COVID-19 pandemic. Today's webinar is presented by Scott Moore, who is the HR and operations consultant for the AAA, and I'm sure is familiar to many of you on the call today. Before we go ahead and get started, I just want to let everyone know that if you'd like to ask a question throughout today's live presentation, you can do so by using that Q&A feature on your menu. We'll try to get to most of your questions throughout the recording, or we'll address them at the Q&A section at the end of the webinar. If there's any outstanding questions that we don't get to, we will be sure to follow up with you via email. And with that, I'll go ahead and get started and hand it over to Scott Moore.
Well, thank you, Megan, and thank you to everyone for joining me this afternoon or this morning if you're on the West Coast. I know that this is one of the, I think, highest attended webinars that, at least from an HR perspective, that I can recall in the 5 years that I've been working with the American Ambulance Association. So I want to thank you for taking the time. I know that everyone is incredibly busy. Not only are we in the middle of a pandemic and some social unrest, but in addition to that, it is summer and folks are trying to deal and balance with children responsibilities, work responsibilities, and hopefully somewhere in there trying to get some time for themselves. As Megan said, my name is Scott Moore. I am the AAA's HR and operations consultant. Been working with the AAA now for roughly 5 years. Been an EMT for 30 years and an employment attorney for 17, and also a certified HR professional from the two certifying entities for as long as, frankly, I've been an attorney. So first and foremost, I want to thank, and I've unfortunately don't have the updated pictures. I didn't hit Amanda up at the AAA for the updated pictures, but want to thank a lot of those folks who are out there on the front lines doing the work every day. I just finished up a 16-year career with the fire department in my community and don't get an opportunity to get out and have not been on the front lines during this pandemic. So I want to thank all those folks who, the brave men and women who are out there doing the work on the front lines and really, frankly, risking their lives and bringing important medical mobile healthcare to individuals around this country. So as I always do, I always say, sort of jokingly, you always trust a lawyer who tells you not to rely on what they say right before they present it. But as always, the AAA and its consultants do not provide legal advice. This is really a presentation intended for educational and informational purposes only, that if you need legal advice, you should seek a licensed legal professional in your area. One of the things we're doing that's new today is a Facebook Live. So not only are we doing the webinar, but we're also on Zoom here, we're also doing Facebook Live. So I'm the guinea pig. I know some people sort of rally on behalf of and try and protect animal testing on, for like cosmetics and so forth, but I'm the guinea pig on Facebook Live. So hopefully there'll be a sign-up sheet for folks to try and keep me from being the guinea pig, but actually happy to do it and excited to sort of try it out. Hopefully it is working. I wanted to quickly, we have just an hour, so I'm gonna move, and sometimes I know my presentations can be like riding a horse by holding onto the tail. I'm going to try and move along quickly enough to get the information out, but then also leave enough time at the end for questions. And to the extent that we don't get to all the questions, I promise you that we can answer those offline. And we talked today with the Workforce Committee, which the AAA, if you're not aware, has a Workforce Committee, a group of folks who get together. In fact, this is the first webinar that was really the brain trust of the Workforce Committee, identifying some of those issues that are out there that we thought needed to be presented on. So we talked today, and we are going to be doing this either quarterly or potentially monthly, depending upon the need. But so today's agenda are just some of the top items that I've seen and the Workforce Committee has seen as issues that have come up for EMS providers around the country. First being permissible employee testing, some of the commonly encountered workforce issues. We are going to talk briefly about PPE and facial coverings, employee leave compliance, as well as some wage and hour compliance challenges that really are out there and are a substantial risk for employers of all types, not just EMS folks, but I think we do have some specific challenges in EMS that make us a little bit unique. And then I am going to touch briefly on some other top litigation concerns, and then hopefully we'll have some time for questions. One of the things that we do, and we said this today, that what the next webinar is will be based off of some of the feedback we received from you. So we're hoping that today and in the future, we will continue to hear from you. Often, a lot of the questions get sent into the AAA, either through the email at info@ or through the form, the listserv form that you can fill out on the AAA's website to engage the different consultants, either myself, Kathy Lesser, Brian Werfel. We want to hear from you and find out what exactly is occurring out in the street. So I haven't actively managed an ambulance service in a long time. I do get a lot of questions from, operations folks and executives and HR folks from around the country. But that's frankly, 90% of those questions are related to the financial relief and the PPP loan programs, not always related to the workforce stuff. And I think folks tend to forget they will look to the AAA for the Medicare stuff, but don't forget we're here and that we want to hear from you, and we will engage, if not folks like myself, we'll engage other folks to make sure that we get you the information that you need. And so the majority of those subsequent webinars coming down the line will be based upon the information that we get from you, because we know that you don't have time in your busy day to necessarily chase down all the information. So we're looking to you to give us information about what it is that you are experiencing on the front line. So one of the first issues that have come up, and I do get this question with some degree of frequency, is, what is our ability to screen or test employees? And specific, I'm really gearing this specifically towards the COVID-19 coronavirus pandemic. And so there are, of course, most folks know, for viral testing, which is that uncomfortable when they scrape your brain with a nasal swab versus an antibody test. And the OSHA came out with some guidance on this probably about a month and a half, 2 months ago, where they said, the difference between and why a viral test is permitted for employees, because viral tests are looking or testing for the active virus. So in other words, you're testing to whether the employee has the virus currently, versus an antibody test, which, by the way, there is some accuracy issues, the specificity and sensitivity issues related to the antibody test. And as you could see, one of the CDC interim guidelines there at the bottom of the page said that even if you had an employee who tested that they had already had the coronavirus, you should not change anything in the way or the practices at your organization. I don't want these folks running around thinking that the kryptonite that could, take them out is no longer exists. And now because they have had the virus that they're, Superman or woman. So what I will suggest to you is the virus test, the viral tests are fine. The antibody tests are considered medical screening, and under the ADA, there are only very specific times that employers can conduct medical screenings. And, we often will do medical screenings at hire, or let's say post a motor vehicle crash, or maybe a drug screening. But a medical screening can also be done if it is job related and consistent with business necessity. Now, I know one of the things that I try to do when I do presentations is stay away from some of the legal mumbo jumbo or some of the specific analysis, and take it to a level that, as an operator, when I was running a service, that would be practical for me. And so really what it comes down to are that you want, or the antibody test also often, by the way, could identify other issues. What you're looking to do, and the reason the viral test is okay, is because as an employer, you have an obligation to provide a workplace that's free from hazards for your other coworkers and as well as your patients. And so one of the things that they identify is if you are trying to identify whether somebody actively has the virus right now, that test is job related and consistent with business necessity, as opposed to the antibody test, which, by the way, may or may not be accurate, number one. Number two, is typically more invasive than what would be the nasal swab, and deemed an ADA screening, so it's not permitted. So just, if you have any, now could your employees voluntarily go get that's fine, but you cannot require your folks to go through an antibody testing. So the other issue that comes up, and the questions come up a lot, are what about testing and temperature, taking people's temperature before they enter the workplace, and that is permitted. Now, typically, taking temperatures are in fact considered a screening and would not be permitted. However, in light of this current pandemic and the incredible contagiousness of this virus, the CDC and OSHA have permitted employers to take or have a process by which they're taking temperatures for employees. However, make sure and understand that you recognize that that temperature collection needs to be maintained, those medical, because those are medical files, just like any of your other employee medical files that need to be maintained and kept in a way that's confidential, separate from the employee's regular personnel file, and the information needs to be confidential. A lot of folks think because it is simply a taking someone's temperature that makes it not a protected health information, or it's not protected health information in the sense of you're not that person's medical provider, but it is medical confidential information about your employees. So ensure that that stuff is being kept confidential in a separate file from someone's other personnel records. So questions that come up all the time is, how much information can I ask of employees when they're calling out sick for shift? A lot of times I've run into, long before coronavirus came along, I ran into a lot of folks who said, when people call in to call up for their shift, we don't ask them why. And I would inquire why they didn't, and how would they possibly do the appropriate tracking for family medical leave in order to ensure that everyone gets their allotted, if they're eligible, they get their allotted 12 weeks of family medical leave. And a lot of folks sort of didn't have an answer for that. What I'll tell you is it's perfectly acceptable to ask an employee why it is that they're not coming to work. That's a fair question. Now, I wouldn't go into significant detail, but it is fair to ask them, especially during this pandemic, if they're experiencing COVID-related symptoms. That is perfectly acceptable. That because you want to know, and you need to know if in fact they're missing that. Number one, for a couple of reasons. Number one, you need to protect your workforce and make sure that if in fact that person is experiencing symptoms, that in fact they go off to see their healthcare provider and find out whether they need to be quarantined or not, as well as you need to protect your own workforce. Additionally, one of the reasons why is that if in fact you are an organization that has decided you're going to, because EMS agencies have the option of providing the Family First Coronavirus Response Act, either sick leave or sick leave in this instance, you do have an obligation. You would want to know that in fact they're requesting this sick time, this emergency paid sick time, for COVID-related purposes, so that you could ensure you were paying them the appropriate amount of money. Just like if in fact they were calling out because their child's daycare or child's school were closed due to COVID, you would also have the right to ask those questions. It's perfectly acceptable. What I would suggest though is you limit your inquiries down to those symptoms that the CDC has identified: fever, chills, cough, shortness of breath, that kind of stuff. It is permissible for employers to ask employees to stay home if in fact they're symptomatic. That's perfectly fine. Oftentimes we know that in EMS, a lot of folks like to reserve their paid time off to the extent they're calling out during a non-pandemic time for the days that they're not sick. What I would suggest to you is it is okay for you, if somebody is sick or they come in and report to work and look sick, that you say, you know what, I think you should go home. That's okay. That is permissible. One thing I forgot to say that I should have said at the beginning of this is, when Brian Werfel does his presentations, he's usually talking about Medicare, which is really the federal law. With employment law, of course, there is generally the federal law that will be overarching all of those individual states, no matter where you are. But often, and is in the case in most instances, there are state laws which tend to be more restrictive, or provide greater protections for employees and employers. And so it's important. I'm not barred in every state, just the state of Massachusetts, the federal court, and the state of Illinois. So what I would suggest to you is that you are looking to your own local, own state law to make sure that you are complying. This is one of the challenges with doing HR-related content, or you do, and there are often times where you will need to check the individual state laws. So you can request when a person returns to work, and I say this with a caveat: if somebody is out for COVID-related reasons, you can ask for a note that says that in fact they are clear to return to work. I would suggest though that you also do take a look at your state laws, because many state laws have paid what would be state mandatory paid sick leave, which have restrictions on when exactly you can request a note for an employee returning. And sometimes it's, in Massachusetts, it's only after the third absence. But my suggestion to you, and I think at least as it relates to the COVID pandemic, I think I would still be checking those state laws. And frankly, in most instances, with someone who is exhibiting COVID symptoms, they're going to be out for longer than 3 days anyways. So I see some questions coming up, and I'm gonna hold off a little bit, just keep moving so that we can get to the slides and the content, and then we will tackle these questions if we end up with some time near the end. So what do I do if an employee refuses to work? So generally speaking, there are limitations to when an employee can refuse to work. Now, that certainly from an OSHA perspective, if there are 2 instances in which someone's concerned, or is refusing to work. 1, because they are, legitimately concerned, and 2, because they are maybe unreasonably concerned. So what OSHA says relative to this is that an employee can refuse to come to work when they perceive that there's a risk of death or serious physical harm. And all of these following 4 criteria have to exist in order for that employee's behavior to be really protected. The first being that the employee has asked the employer to eliminate the danger and that the employer failed to do so. The second, that the employee refused to work in good faith with a genuine belief that actual danger really exists. And then third, that a reasonable person, so it's not just the employee's own subjective feeling, that a reasonable objective person would, faced with the same exact situation, would also feel that there in fact was a serious risk of death or physical harm. And then lastly, there isn't enough time due to the urgency of the particular hazard to get it corrected, and the employer hasn't responded. So through the regular enforcement channels. So what that really means is, functionally, if someone calls you up and refuses to work, I wouldn't blanketly tell them to come to work. That's the call that you need to be asking more information, because for all you know, while we all like to think that we know what's going on out in the multiple satellite locations that many of us have, for all we know, it may very well be that one of our employees perceives or actually finds that there isn't enough PPE at one of the locations, or that the safety equipment, or that there are conditions at one of your locations where people are not following your infection control and your COVID response plan that your organization really should have. So it's important to understand that, right, that if somebody calls up and says, I'm not coming to work because I'm concerned, I'm afraid, you need to dig deeper, because there are some situations in which a person may have an underlying health condition. And that, for example, maybe they are at significant risk, they're immunocompromised. There are any number of reasons. Sometimes we've heard things like women who were pregnant and were concerned about, in catching the particular virus. In those instances, what I strongly recommend to employees, and what you're really obligated to do, is to go through and do some searching, just like you would if you had an employee who was requesting a reasonable accommodation under the Americans with Disabilities Act. So you would go through what's called the interactive process, which is a dialogue and an engaged dialogue between the employee and the employer to understand what exactly is the person's concern, what are they asking for, and if in this instance it's just, I don't want to come to work, you are able to ask for them to get some documentation from their own healthcare provider, which should help you. And now I know, oftentimes, in looking in years and dealing with family medical leave, we'll find healthcare providers who really don't care one way or the other, whether the employee, if the employee is concerned and says, please fill this out, I'm concerned about going to work, the doctor sometimes will do it. Most instances, this is where having some education and training behind managing family medical leave, probably one of the #1 biggest areas for compliance concern in specifically in EMS, is really, really important, right? Understanding when and how you can ask for additional information, following the process, right? The steps and the timing of when and how you have to provide notices to folks, et cetera. And in many states, you're required to document that interactive process. The city of New York, for example, I say it is a good practice no matter what. If someone comes to you seeking some type of accommodation, you want to ask them and document. I would ask them to put their request in writing, and then I would document the entire interactive process. Employers are not obligated to provide any accommodation. They're only obligated to provide reasonable accommodations. And reasonable accommodations, right, are ones for which do not involve great expense and do not involve great difficulty. So what does that mean? Well, that really is a very case-by-case analysis. So what I would suggest to you is that you, and this is the instance in which you would call, let's say, the AAA and reach out for help and assistance with this, or one of your local council folks. So somebody refuses to work. It's not just simply you have to come to work. It is there, you have to dig deeper. Of course, there are issues related to the National Labor Relations Act for organizations that are unionized. There are instances in which, as part of contract or a collective bargaining agreement, employees have the right to refuse certain assignments. That's really another entire webinar. And I know that given that only about 6 to 7% of the workforce in this country are unionized, I won't dedicate a ton of time for this specific topic, but certainly can help folks with that in the event that they have those issues. If there are state or local closure orders, I would be very cautious about mandating non-essential, so possibly your office staff to be coming in if in fact you have a state or local closure order. We wrestled with this a lot of members wrestled with this early on in the pandemic about whether their billing folks were considered essential employees, and we worked through a lot of those issues. If you have someone who is able to potentially work from home, and that is something you can do so safely with all of the safeguards, then you probably should do that in the event of a state or local closure order. The challenge, of course, now is prior to COVID, we had a lot of folks who could say, my folks can never work from home. We've pretty much proven that that's not true anymore. That for the most part, the technology exists where folks who do administrative type positions can work from home. And from here on forward, I hate to tell folks that it's going to be really, really challenging to try and suggest that you can't accommodate an administrative person who's trying to work from home if they have a legitimate protected disability under the ADA. But that again is a case-by-case analysis. And then one of the other issues are you have to make sure that if your organization is providing the emergency leaves under the Families First Coronavirus Response Act, that you're tracking that time, and that because you are mandated under that law to track any request for and use of the emergency leaves. So that we spent longer on that one than I think I thought I would have, but we'll move on to the next one. Can I require my employees to wear facial coverings? This is a big issue these days around the country, and there is a lot of people arguing about the efficacy of face covering. The pesky little things called facts. The fact of the matter is facial coverings are in many states mandated. They are in fact shown to reduce the transmission of this contagious virus. And so may you require your employees? You absolutely may require your employees to wear facial coverings. Now, that being said, many of our employees are already using OSHA approved PPE, and that of course should not change anything. But when they're coming back to the office location, when they're coming back to the station, they really need to be wearing facial covering. No one likes them. I don't blame folks. I don't like wearing them either, but the bottom line is that if your state has an order that you must be wearing facial coverings whenever you are outside of your home or in a retail establishment or at work, and many states, by the way, have requirements that offices on the reopening do require their employees not only to wear facial coverings. In fact, in many instances, they require a whole lot more than that. So what I would say is, yes, you can require, if you have an employee who says, I have a medical condition for which wearing a facial covering is incredibly uncomfortable. What I would suggest to you is to go through the reasonable accommodation process as well with this individual, because while it's uncomfortable, it doesn't necessarily mean that there is a negative physical outcome because of that, right? They're uncomfortable for me too. This comes back to if folks don't have some legitimate covered disability that would forbid them, or it would be dangerous for their health to wear that, and they have documentation from a healthcare provider, then other than that, they really should be wearing it. But again, this would be one where you'd want to engage your local council as well as go through that interactive process. A lot of PPE concerns, not only, thankfully, I think many of our members have been able to access PPE. We had a lot of trouble in the beginning of this pandemic getting access to it. And of course, as many of you know, we were upgraded from number 5 in the list of priorities for PPE to 3. Thank goodness. We should be probably 1 or 2. We were able to get upgraded, thankfully, as the work of a lot of folks, not only at the AAA, but some of the other EMS advocating organizations out there. But are we employers obligated to provide it? The answer is yes, we are. And then I often get asked, can my employees use their own PPE? And the answer to that question is also yes. But remember, if as an employer, you allow your employees to wear their own PPE, you are responsible for ensuring that it is adequate, that it in fact includes proper maintenance and sanitation of that equipment. So once your employees come in using their own PPE and you permit that, you are obligated, you're on the hook from there on out to make sure that that is adequate for its intended purpose, as well as making sure its maintenance and cleanliness are maintained, disinfection. So it's really up to you. A lot of organizations have just gone ahead and issued a reusable PPE to a particular employee. I think that is becoming, you know, instead of the disposable mask, that is becoming sort of what a lot of folks are moving towards in the standard. You know, what happens if your employee loses or damages their PPE? And if an employee does lose a piece of equipment or has intentionally damaged that PPE, the question is, can you or must the employer pay for that replacement? And the answer is, unless the employee has lost what was an issued piece of equipment or a intentionally damaged piece of equipment. So intentionally damaged, not just negligently damaged. My suggestion is, if your employees lose or intentionally, you know, or damage a PPE, then I would replace it at no cost to the employee. I would discipline as necessary if you in fact find out that your employees have lost equipment or have intentionally or negligently damaged it. I think be careful with the negligent damaging. I think it would be, you know, if they just were not paying attention or being careful and it got damaged, that would be something that I would address through corrective action or really performance improvement. The case at the bottom here, the Tony Evans as special administrator for the estate of Wando Evans versus Walmart, really is an interesting case. And by the way, there are several websites out there that are tracking COVID-related litigation. And we are, as almost all of the HR groups are saying, we are facing a wave. We are at the beginning of what will be a litigation tsunami related to COVID-related claims. So this particular case was an individual who unfortunately did pass away because of COVID, had been complaining about to the employer that they weren't in fact following the appropriate facial covering procedures, were not governing or ensuring that employees and customers were remaining 6 feet away from each other, following the social distancing, that they were not following the preventative measures recommended by this CDC relative to disinfection of the workplace. And they believe that that was the proximate cause of Wando Evans's passing. And so this case, none of these cases, of course, that we're going to talk about today have been litigated yet. They've just been filed. And as many folks know, nearly in every instance when a lawsuit is filed, the intent is not to end up in court. In fact, you've lost in most instances if you've ended up in court. The goal usually is for these things to get resolved prior to litigation. That road is a long one, often several years, 3 to 5 years before a case will typically get resolved, and only about 4 to 5% actually ever end up getting tried. So this case, demonstrates, and I thought about employers in particular, ambulance service employers who have not either established an appropriate cleaning regimen or disinfection regimen at their organizations, not only in their public areas or their office areas, but as well as their ambulance stations and their ambulances. I know we're generally pretty good about disinfecting ambulances, and in particular patient compartments, but we need to have the same level of diligence in our infection control plans for all locations within the organization as we would in as we would if we were talking about the patient compartment. In this instance, they were essentially saying that they had a willful disregard for this entire process. So what does OSHA require? Well, they require that the employer provide some sort of hazard identification and assessment, and they have plenty of tools that employers can use. You go to this website right here, there is in fact a whole host of tools that employers can use to go through and do a hazard and identification and assessment. Additionally, of course, we all know we're required to go through the infection, bloodborne pathogen, airborne pathogen training and standards, and this should be occurring really on a regular and ongoing basis, but absolutely at least annually. So if you do not have records and cannot demonstrate that, in fact, your employees have been through this training, you need to get on it immediately. Of course, there are plenty. I know in-person training is really challenging these days. There are plenty of great online platforms that are available for folks to get and provide this training to your staff. One of the other issues that have come up are issues about when an injury or an illness is reportable. And generally speaking, an injury is recordable if it's a confirmed case of COVID as defined by the CDC. It was work-related as defined under 1904.5, which I'll talk about in 2 seconds. And the case involves one or more recording criteria. So 1904.5 really says it was caused or contributed or was a significant aggravator of either the illness or injury was caused or contributed to by work and or was aggravated an underlying condition or injury, as part of in the course of your work. The other part of that is it's recordable if it results in death, days away from work, restricted or work transfer, medical treatment beyond first aid, and or loss of consciousness. That involves diagnosis by a licensed healthcare provider, even if it didn't involve days away from work. So I have down here hospitalization. If you have, and I know one of my old partners was hospitalized for COVID, if you have an employee who ends up hospitalized, you have to make a report to OSHA within 24 hours. And in the unfortunate instance that you have an employee who has passed away because of COVID, you have 8 hours to report that COVID-related fatality or any work-related fatality. Now, oftentimes an employer will not know for some time after the employee's death whether in fact it was COVID or work-related. It is from the time that you learn that an employee has died as a result of a work-related injury or a work-related infection. And it may very well be that you don't know that until you receive the death certificate. In that instance, you then, as of that point, have an obligation to notify OSHA that in fact you had a workplace fatality. I will tell you, they are maybe not right away, but they tend to have someone at your place within a day or two. If it's in fact as a result of an injury, you typically will have somebody on scene within a couple of hours. So those requirements are pretty straightforward, and I see the questions are loading up. We've got at least 7, so I'm going to keep rocking, but I will get to the questions because we're on a good path. So I think a lot of you probably saw this lawsuit, the ambulance lawsuit that was in most of, not only all of the newspapers, certainly locally, but also here in, not here, in Nashville, as well as EMS-1 and GEMS. There was essentially what this was one of the ambulance services that were activated as part of the FEMA contract responded to New York. This employee alleges that essentially they were told they'd be paid for 24 hours. They then got on, they got there and were not permitted, essentially after their 12-hour shift. They were sent back, transported back to the hotel, that there was a security guard at the hotel, that they weren't able to leave their room. They weren't able to use their time as they saw fit. They weren't able to do a whole host of other things. Interesting when you read the story, the items that they chose to identify what they weren't able to do. But needless to say, this employee is essentially alleging that there is a wage and hour claim here. There is and are a lot of moving parts on this particular case, and I don't know all the facts. I tried to find the individual filing. I haven't found it yet. But there are, I will tell you, in the litigation tracker site that I was able to find, the #1 most numerous litigation tracking issue was wage and hour complaints. No surprise. And I think in all of those, the claim that's associated with most of those are whistleblower as well, because the underlying issue almost always accommodates some type of whistleblower complaint. So in most instances, this is again, and when you look at when you read the story says essentially that their counsel said that they vetted out their pay practices with both state agencies where these folks were working back in their home state agencies, as well as with their own legal counsel. I don't put any opinion out there as to what or when or how there's any legitimacy to the case. Oftentimes lawyers will not file a case unless they believe there is enough there, because there can be some sanctions against lawyers for filing cases for which they do not believe there is a legitimate basis for relief. So as we both know, or as many of us know, there is the engage to wait versus waiting to engage, right? And it really comes down to how free am I to do with what I want with my time? And in this instance, it sounds like, even though they were at the hotel, it sounded a lot like essentially it was still working time. Again, there are times in which employees, if they have 5 hours of uninterrupted sleep, an employer doesn't necessarily have to pay them for that time. I have, when asked by people who were responding to that contract, when they asked my legal opinion as to what I thought they should do, I said, you should be paying people and ensuring that people get minimum wage for all hours that they are deployed, at least minimum wage. Now, how that works out, and if they can in fact ensure that these people get certain break times and that they are in fact relieved of duty completely, that they're not on call, that they're not going to get activated. There are a whole host of facts that I've never been activated, but I would suggest the easiest and cleanest way is to pay folks for the time that they're gone. Other wage and hour concerns are relative mostly to timekeeping and or incentive pays and shift differentials. A lot of ambulance providers offered incentive pay or differentials or hazard pay. And when that happened, what they did was put themselves into a situation where you need to do, when you hit overtime, you needed to do a special calculation for overtime, for a weighted average overtime. So if certain shifts, this was commonplace before the pandemic when we were having a hard time staffing units. So we would have employees who we wanted to incentivize to work certain non-emergency trucks or certain weekend shifts. Oftentimes employers where they ended up into very, very deep or hot water relative to wage things, or they were not paying the weighted average overtime rate to these employees that accounted for that differential or that incentive pay. If you are an organization that is paying some form of hazard pay or some shift differential or some other incentive pay, make sure not only that you are accounting for that and making sure that those calculations are done correctly, but don't presume that if you put it into your payroll system that the calculations are coming out correct, because we did run into a situation about 2 years ago where I found that several of the large national payroll companies, their formula within their payroll, where you call up an employee, your payroll company, and say, I want to add a differential. And the person on the other end of the phone knew the customer facing person would say, oh, I know I go to this field for differential and I just have you put this in here. But what they didn't know was the implication behind it. In other words, they didn't necessarily realize that created a new calculation for overtime. And so what we found, and I ended up on the phone with several of the payroll companies' corporate counsels expressing to them why I thought they were calculating the overtime rate wrong. And fundamentally, we did come down to a solution and they fixed what was broken. I will tell you, it was the 3 of the biggest providers in the country. That being said, so don't presume, even though they are the payroll experts in most instances, you need to make sure you're checking up with them. Their mistake will not necessarily alleviate or mitigate your responsibility or your liability. That being said, you likely, if you look at your payroll processing contract, you want to make sure. Many folks sign those contracts without reading them and don't recognize that they're generally drafted in favor of the party who drafted it always drafts them in their favor. So make sure that you're looking at those contracts. Often we all sign those without really looking at what the indemnification provisions are, et cetera. So do be looking at that. Donning and doffing pay. If you are medically screening people on the way in or on the way out, be sure that you are paying people, that is the equivalent to making them put on equipment. If in fact an employee has to put on equipment like SCBA or something before they come into the workplace, you want to be paying them. If they're tied up for 5 or 10 minutes in line waiting to be able to get their temperature taken, you need to be paying them for that time. Trust me, in the grand scheme of things, it's not going to amount to a ton of money and you will avoid a whole bunch of headaches. Paid time off, there were a lot of lawsuits tied around not only the Families First Coronavirus Response Act emergency paid time off, but in addition to that, other time off provisions that either were state paid, mandated, or employer provided. And just essentially instances in which people were not paid because either the employer had a pretty substantial downturn in their funding or in the money that they were the receivables, and as a result they were in a position where they couldn't necessarily afford what they had committed to. That being said, if you haven't taken a look at your pay practices, you need to. Now is as good a time as ever. Like I said, this by far was, I think, at least 2 to 3 times the number of claims or litigation tied around COVID were related to wage and hour concerns. So moving on, work from home. And I want to thank Rob Lawrence, and I'm drawing a blank on her name right now, but one of the members from California. California is the Wild West when it comes to employment law. There is an entire separate certification for California. I love California, and I wanted to get the certification for California, but they wanted you to take the whole certification class over again, plus the California piece, which didn't seem worth it. Thanks to one of our California members. Under the federal law, what they say is you can't require an employee to bear an expense if they happen to work from home. You can't require that they bear that expense. In other words, you're going to tell them they have to go out and buy a computer. You're going to tell them they have to get Wi-Fi. If, in fact, to work from home, they had to get Wi-Fi or they had to buy, you should be providing that equipment. In California, one of the things, though, that is a little bit different than the federal law and the federal law, it's not that this isn't required, it just doesn't speak to it. But in California and in a couple of other states, there is a requirement that if your employee is using, let's say, their own computer or their own Wi-Fi or their own phone service, that you need to provide them with some reasonably calculated stipend for that amount of, for an amount of money reflective of your imposition on their expense. While I recognize they might not have greater cable expense, they might not, it would have been something they had anyways. They might have already had a computer. They might have already had a cell phone plan. Maybe it's even an unlimited cell phone plan. It does not matter, right? Cleanest, number one, most compliant way to avoid any of this is to come up with a calculation and pay those folks who, thank you, Rob, it's Melissa Harris. So I want to thank Melissa because she was gracious and provided me with some great, the case, the citation, everything. So that being said, come up with a formula, make sure you document that formula in the event that anybody comes back to question you, you can point to it. That is always a good practice, right? So employees should not bear the expense as a result on their personal expenses as a result of working from home. So we've heard a fair amount early on some discrimination and harassment issues, in particular about folks treating individuals from China differently. As ludicrous as that sounds, because a lot of folks felt that was where all of this began. The reality is we have laws in this country that suggest that you cannot discriminate or harass people on the basis of national origin, gender, age, pregnancy, gender identity, sexual orientation. I can go on. Needless to say, right, I want to, before I start this part of the presentation, talk about how somebody proves a discrimination case. There's something called the McDonnell-Douglas burden shifting. And this is when an employee essentially walks into either the EEOC or your state level discrimination regulatory agency and says, I have been terminated because of my age, my gender, my sexual orientation, my national origin. I have now stated a claim upon which relief could be granted by the EEOC. At that point, the burden shifts over to the employer to answer that complaint. Scott says, employer Scott says that he was fired on the basis of his age or he was fired on the basis of his gender. The employer then has the burden shifts to the employer to state their legitimate non-discriminatory reasons. So in this instance, Scott says he was fired for age. They say nonsense, he was fired because he was a terrible employee. The burden then shifts back to Scott to say, all I have to do now is show that my stated reason, their stated reason, the employer's stated reason, no, it was because he was a terrible employee, is not likely their real reason. I don't even have to prove that their real reason was that I'm a terrible employee. I just have to prove that their stated reason is not likely their real reason. How would I do that? Well, Scott was a terrible employee. Here is Scott's performance review from the last 3 years that say he's exceptional or at least meeting expectations. I see nothing in Scott's file that says he had any performance related problems. So once I have shown the EEOC that their stated reason is not likely their real reason, the burden shifts back over to the employer to overcome that. Employer, you've told us that Scott actually is a terrible employee, yet his file shows that he's actually pretty good. What do you have to say? And how do you recover from that? Well, don't pay attention to those performance reviews. Our supervisors really don't put any effort into those at all. And we really stink at disciplining employees. In fact, we're horrible at it. You've lost there, by the way. But if you can't overcome or rebut that, then the trier of fact is entitled to presume that because your stated reason is not likely your real reason, it's likely an illegal reason. And so I start this section with that because you need to understand this is why if you call me and say we're being accused of discrimination, I will ask you a bunch of questions. What's in the personnel record? You know, employees who say, we need to fire this person, they're terrible. The reality is I go to their file and there's nothing in there. And so that's why we stick to these things. So national origin, age, these cases are interesting. The first one being Lynn versus CGIT Systems Incorporated. This is a Massachusetts case, and I didn't pick it because it's Mass, but it is a Massachusetts case. This was a 55-year-old Chinese American who had high blood pressure, and he essentially alleges that he was fired because of his disability, his age, his race, and his national origin. He had better than the trifecta. He had them all. He says he was. So he essentially asked for, during the early work from home order that Governor Baker issued, he asked to work from home and they said, sure, go ahead. And at some point, the employer, actually it was late March, which is insane to me because things were really heating up in late March, said everyone's got to be in the office on March 27th. He communicated to them, listen, the governor's got a stay-at-home order. I think I should stay at home. I am concerned because I have high blood pressure. And he made a formal request to stay home. And by the way, the employer said, no, you need to be here. Number two, they let 2 other employees work from home. And the plaintiff then says that on the 31st, which was not the 27th, 31st, that the boss told him he had to come to work. He reiterated his concern, and then a few days later, he gets a note that says he's abandoned his job. All right. The age complaint. The age complaint is one. It's a case out of New Jersey. Matt and Margaret, who I believe are on the webinar today, could probably speak better to this than I can. But 70-year-old salesperson claims essentially that he was discriminated on the basis of his age and disability, and that they retaliated against him against the New Jersey's whistleblower law. This particular defendant says that they closed their facilities after one of their employees tested positive. After they completely disinfected the office, he had asked, are you going to be disinfecting the office? They said yes. He was the only employee who was not returned to the office. Now, the employer may have had their own concerns about this older employee's health, but they never said anything to this employee. This employee, who was a salesperson, wanted to return to work. They allowed everyone else to come back to work, did not invite him back to work. And he essentially says that, I was constructively terminated. That instance, right? Everyone else gets invited back to work. So you may, because your older employee requests to stay home, and if you have no objection, you may provide that accommodation, but you cannot summarily, just as you can't with individuals who might be pregnant. We run into this all the time with women who are pregnant and want to continue to work as long as they can in EMS. And at some point, people get concerned that the lifting or the strains of this job may be harmful to the mother or to the baby. That's not your decision, right? As long as that person can meet the essential functions of that job. So we had both a gender and pregnancy related discrimination as well. This also another New Jersey case in which the employee asked, she said, look, I have a high-risk pregnancy. Her doctor suggested that she work from home. The employee asked to have to work from home, and believe it or not, this is one of the best of all, that she was reported for having, when she was terminated because she didn't come back to work, she was terminated for having a negative attitude. So in these instances, what I would suggest for you is, with all of these things, when you have an individual who, one of the first, if you call me up and start to discuss a particular issue, I'm going to ask you a few questions. What's the gender, national origin, the age of the person? It's not because I'm looking to discriminate. I'm looking for the potential legal implications that are associated with those protected categories. While very few employers, thank goodness, I mean, there's still a lot of discrimination and harassment that occur in the workplace. I think a lot of our folks are doing it right. But what I will say is, just because you didn't discriminate doesn't mean you don't have to watch out for these things. So in all of these instances, right, it's about treating people alike, regardless of their differences, right? Like positions treated alike. So employee leave issues, a lot of Family First Coronavirus Response Act. Now, I know a lot of employers, especially in particular EMS employers, decided, because they were permitted to exclude emergency responders or healthcare workers. And so under the Families First emergency responder is an employee who is necessary for the provision of transport, care, healthcare, comfort, nutrition of patients, or whose services are otherwise needed to limit the spread of COVID-19. So my question is, does this, and I've received this question, does this also include the office folks? Because I've had many people say, well, without the billing occurring, we can't provide the service. And that question's not been answered. My suggestion would be is that if in fact your billing folks can work from home and or you are in a position to offer that leave, then in the most compliant of ways, you would offer that leave. However, it is not clear from the law whether those individuals are counted or not. And there still hasn't been any guidance on this. So really important that if you've decided as an employer that you're not going to provide, I know a lot of members did, because I've heard from a lot, that's great. There are some posting requirements that you need to post relative to the Family First Coronavirus Act in the area where you normally post your stuff. And I know a lot of people don't have folks coming to the workplace. So it is okay to also have an electronic. You must have it on the wall. That is required. But you should also, for your remote employees, have it somewhere in a conspicuous area, preferably your login screen, for your employee intranet. That is important. Posting requirements. Also, if you've decided to exempt your employees because they are in fact emergency responders, you should provide them with some kind of notice that says, hey, you've heard of this thing called Family First Coronavirus Emergency Paid Sick and Emergency Paid Family Medical Leave. We are an emergency responder. I have a notice that I've actually provided to my clients. I'm certainly happy to share that says we are an emergency responder as defined by the Family First Coronavirus Act, and we are exempt from this particular, we've chosen to exempt from this particular type of leave. The issue have come up, and in the leave cases that I've seen, many of them are tied to the interactions between not only the Families First Coronavirus Act, but the different types of leave. Because family medical leave always been a challenge in EMS, of course. And this particular case, and I looked, I don't believe this is a AAA member. Not that I wouldn't have put it up there, but I don't believe it's a AAA member. This was a particular flight paramedic who asked about the possibility of taking emergency paid family medical leave under the Families First Coronavirus Act. And so he had asked, he was a flight paramedic, and he was told at some point he was terminated, and he was told that when he questioned about leave that he, quote, ruffled feathers at the top. This is not a case I would want to be defending. Now, whether that's in fact true or not, remember, this is only one person's assertion within this particular piece of litigation, but these are one of those ones where I would be very, very, very cautious. Again, this Kelly Newdall, and I'm probably butchering that last name, versus the Progressive Parma Care Center. This was an activity director who essentially alleges that the employer interfered with her right to take family medical leave. That, by the way, is a pretty common claim right? Family medical leave, not emergency paid family medical leave, but family medical leave. So it's traditional family medical leave. If you do not have, and you should be using the federal forms, but federal folks don't have a family, FMLA request form. If you don't have one, reach out. I have one. I'll be happy to share with you. On top of that, you should have a process by which that has all of the dates lined out for you, and you should log every single family medical leave, every request for leave of any kind. Because in the times where I've represented clients with the United States Department of Labor, my old employer, the first thing that they ask is, hey, I want a list of every individual who has requested leave of any type for the last 3 years, when they requested that leave, when you responded to that request, what the response was, and whether you approved or did not approve that leave. Many employees, and even when I look back to my time as an HR director, we often kept that information in the different employees' files. You do not want to have to go back and try and find that because one, God forbid you forget or miss one. It's easier to have a log, and you can also, by the way, this comes from CAS, you can trend and make sure that you are treating people similarly. That's critically important. And it also reduces the likelihood that you're going to miss responding in one of the very time specific responses. So this particular employee was diagnosed with COVID. Now, not everybody who's diagnosed with COVID necessarily will that equal a serious health condition under the Family Medical Leave Act, but she requested the leave paperwork. She then never received the leave paperwork, but gets a text message, and this one's a beauty, from management that says, I understand that some leaders are going to step up and some leaders are going to step back. I wish you well. Great employer. So next one, there's nothing to say there. You need to have a process. You need to make sure that you're following your process. The next sort of set of cases, and I know we're running up to the food, we may run a few minutes over, so I'm sorry for those folks who have held out. Disability discrimination. In this one particular, Rumble versus JMAC Steel in San Bernardino, California, pregnant employee concerned with contracting COVID asked the employer to implement the safety precautions that had been recommended by their state and by the CDC. She complains, hey, look, my coworkers aren't practicing social distancing. They're not wearing facial coverings. Think of your office right now and ask yourself, are your employees in your own ambulance service wearing facial coverings in your office? If they are not, think of this case. Employee complains to management, gets terminated, right? And I don't know, by the way, what the reason that they gave, but I'm sorry, they did. Poor performance. Now, in this instance, think about the burden shifting. At some point, the EEOC, or in this instance, California, will reach out to that employer and say, okay, you've said you fired her for poor performance. Let's see her personnel record. There better be something in there. And if not, by the way, they are entitled to infer it was for the illegal reason. So we are winding up another disability case. This is an employee quarantined under a doctor's order. He interacted with an individual who had suspected COVID. This individual, because of his underlying health conditions and weakened immune system, said, look, I need to take, I've been quarantined, I need to take emergency paid sick time. The boss said, why would I give you sick time if you're not actually sick? He then gets terminated for lack of performance. Again, I know I'm sounding like a broken record, but recognize, my recommendations are analyze every single position you have, every job description in your organization. And if you don't have a job description for it, get one, but understand, what are the essential functions of this position, understand where can this person work and when, in other words, could we potentially accommodate them doing something other than what they do, right? And it's not like these aren't predictable. You will have employees who become pregnant. You will have employees who have weakened immune systems. You will have employees who have other issues. These are relatively predictable stuff. You should be analyzing these things, taking a look at it, right? Finding out if in fact you've had an employee who's demonstrated for you that they already have a reasonable accommodation, you need to revisit that reasonable accommodation now. Because just because it was an accommodation that was reasonable at the time before COVID, it may not be reasonable anymore. And in fact, you need to revisit that because they may need something additional. Moving along, off-duty conduct. This has come up a lot, in particular with regard to COVID, in the sense of people taking vacations to places where, let's say for example, Florida, where it is COVID crazy right now, or that you've seen them on social media, and social media is our next page, out doing things like participating in a protest. Now, it's in many states, 30 states have laws that protect some form of off-duty conduct. For example, New York, you cannot discriminate against an individual for their political activities. Now, that doesn't mean that you couldn't potentially terminate someone for participating in an illegal manner in a protest if they were doing something illegal. What I would strongly suggest is before you take any employment action on employees that you consult with your local counsel. That being said, if you have employees who decide to travel, and I've got a lot of these questions, can I tell them they can't come back to work for 14 days? Many states, my state, if you come into my state from another state, you are supposed to quarantine for 14 days. So yes, you absolutely can, provided you do this consistently with any employee who does it. Don't do it for some and not for others. That would not be appropriate. And by the way, even if you came up with some reason, our billing people, they don't interface with our patients, so we're not going to make them, but we are going to make our EMTs and paramedics. Again, you're opening the door for someone saying, here, we're both employees first, and you've treated us differently. Now, granted, different jobs, but don't do that. The social media thing, I get a lot of folks who say, employees go, I have a free speech right. And I know I looked on the Reg list, we had a lot of governmental entities here, and we were probably already been educated about this, I'm sure. In certain circumstances, certain governmental employees do have free speech rights. Private employees, you have no free speech rights outside of potentially concerted protected activity that's protected under the National Labor Relations Act or whistleblower complaints, good faith with whistleblower complaints. Other than that, you can be fired for what you say on social media. Generally, as long as it's not protected concerted activity, you can be disciplined for saying things, and we've seen a lot of these, if you lay down in front of my ambulance, I'm gonna run you over. Don't do that, right? We as an industry have been fighting for years, decades to be recognized as a profession. We don't often see doctors or nurses online saying, you come into my ED and I'm gonna club you. You just don't see it, right? These are the things that undermine the profession as a whole. So needless to say, what I would suggest is make sure you have a social media policy that has been reviewed by counsel, right? Because there are some National Labor Relations Board guidelines around social media policy. The one in the AAA's handbook is good. And I did draft it, but it is consistent with the National Labor Relations Board's rulings. That being said, make sure that your employees, it's been communicated. They don't always know. Folks seem to think, right? They can call out sick and then show up on Facebook and they're the ones who friended you. Not bright. And yes, you can discipline for that. So what I would suggest to people are, if you see people, make sure that your practice is consistent. Make sure that you are often doing, it is regularly enforced. It is consistently applied to all employees. Make sure that you're educating people about how their behavior impacts others, right? That if in fact I had a client who asked me to draft a memo, if you take a vacation out of state, we're going to require that you don't come back to work that you quarantine before you return to work for 14 days. Just make sure you know that. So that is okay. All right, the CDC has put out a lot of guidance and OSHA as well, and DOL, of course, about preparing your workplaces. Make sure that you are communicating to your staff and that you can show that you communicated these things, right? When we have employees who are filing cases saying that we're not, practicing diligence with regard to infection control, you want to be able to show your organization's documents. That's the first thing I asked for as a Department of Labor employee when I was dealing with a complaint is let me see all of your documentation relative to X, Y, or Z. All right. And then the other thing is ask your employees, talk to your employees and find out. So questions I have, RJ, when sending someone home with symptoms, are you required to still pay them the 4 hours? So if you have an employee, many states have reporting pay requirements. If you have an employee who comes in and then gets sent home before they have gotten the minimum number of reporting pay hours, then yes, you should be paying them. That being said, again, talk with your local counsel. Melody, as an EMS agency, I've been looking for what testing guidelines are for testing employees, and I'm not finding anything specific other than symptoms monitoring. Are there general guidelines for testing employees, and if so, how often? I have to tell you, the best guidelines that I've seen, which are admittedly not how often you need to be testing them. Early on, Dr. Rock, who is a wonderfully amazing guy, had suggested that you pick your couple of true sources of information. CDC is probably the #1 source of true information. There are some guidelines on there loosely. The EEOC also has guidelines about what you can and cannot do relative to testing. Certainly, Melody, I can connect with you after this, and I'm happy to point you to the resources that, that I'm aware of. But admittedly, there are not a ton because it really depends on the individual test. What if an employer refuses to go to a facility because it's known to have a large number of COVID-19 patients? You would have to want to talk to that employee and go, why are you afraid? Do you believe we don't have the appropriate protective gear? Do you believe you've not been trained appropriately on how to appropriately use your protective gear? And by the way, you should know or suspect that everyone you encounter has COVID. So you should be practicing those, scene safety and, body substance isolation, right? I'm showing my age. You should be practicing those good infection, bloodborne, airborne pathogen control practices all of the time. If the employer refuses, you want to make sure that their fear or their concern is actually, if it's reasonable, you need to address that. If it is unreasonable, then you can address that as well. If an employee states that they have a close family member with hypertension, heart disease, and they state they do not want to come to work to preclude from putting that family member in danger, should we attempt to provide a reasonable accommodation for that? Let's say both scenarios, family lives with them. Great question, actually an outstanding question, Tanya. So this question came up a lot, and in the ADA, they're really, really clear. So people are protected in the ADA, and I'm not suggesting that that person's particular medical condition reaches the level of a disability under the ADA, but what I will say is this: if you can accommodate them and it doesn't cause you great harm or it isn't unreasonable, then I don't know that I see any harm with doing that. That being said, the EEOC has guidance right on their website that talks about this very issue. You are not required necessarily to provide, this is not as the being associated with a person with a disability. I would still go through that interactive process with them, because most of our folks who work in EMS also live either with a parent or with a child or with a spouse or some other family member who has underlying medical conditions. By the way, there is the one downside to getting old that I have noticed is that I'm not as healthy as I used to be. So by the way, most people at a certain age are going to have certain things happen with them. So no, there is not an obligation to. I say that reserved in the sense that if that person truly does have a disability, and if you're treating them differently because of their association with that person, that's a different issue. But are you obligated to accommodate their request to essentially not come to work because they're concerned about somebody at home? I believe the answer to that is no. Great question. If an employee is collecting unemployment when, that bounced up. If an employee is collecting unemployment when our hours decreased, but now our hours have increased and we need them back, can they stay on unemployment? What is the process to get back to work? Great question. Make that offer to come back to work in writing. You want to do this for the PPP plan. There is a safe harbor under the Paycheck Protection Program and the forgiveness application that says if you made them a legitimate written offer to return to their work, but of course they're getting that $600, which expires at the end of this month unless somebody continues it. I think it may, but I'm hopeful that it doesn't. And I mean that as not a political statement. I want people to be able to come back to work. They shouldn't be better off for not working than they are for working. But in any event, in this instance, make them a legitimate writing, an offer in writing, and tell them that if they refuse the offer, that they may not be eligible for unemployment. If they do refuse the offer, I would contact your state unemployment office and let them know. You made a viable offer to this employee, they've refused the offer, and really the state unemployment office hopefully will take action, no guarantee. New guidance update on EMS issued today. Oh, Rob, thank you. I did not know that. I will look for it. And he included the URL for that. So we will do something today. I'll send out a member advisory on that later on today. What was the time requirement for reporting hospitalizations? 24 hours, Con. 24 hours you have to report a hospitalization. Now, it may be very well that you don't know about your employee being hospitalized until 36 hours later. Once you know, 24 hours. We have to record COVID cases on the Form 300. Great question. If in fact it is a work-related COVID case, and I talked about this earlier, right? You would need to report it if in fact, I mean, and they would have gotten diagnosed, I would report any COVID case that you believe is work-related on your Form 300. Because they will have days away from work anyways. If you believe it's not work-related, very hard to pick, but I would report it. Can an employees with morbid obesity be addressed due to PPE, job descriptions and duties? I'm not sure I understand the question, but I wonder if what you're asking is, if I have an employee with morbid obesity and I can't, let's say, appropriately fit them with PPE, you do have an obligation to provide all of your employees with the appropriate PPE. So you may actually have to go out and find PPE that fits that individual. There are actually entire head hoods that, which we will often use for individuals who have certain religious accommodations. So folks who can't be clean shaven and make either a qualitative or a quantitative seal as a result of their facial hair, which is part of their sincerely held religious belief. If that's the case, you would want to go through that interactive process. Often with folks who have religious beliefs, you can keep it very cleanly trimmed. You can still make a qualitative or quantitative seal. But otherwise, you would have to provide them with an alternative, same with your obese patients. Now, if the question was, do I have to do something different and special for my morbidly obese? In most states, there are one or two, most states, there is, morbid obesity is not necessarily in and of itself a disability that's protected. There are conditions or comorbidities to morbid obesity that actually make them a disability, that are disabling conditions, which would require you to go through the interactive process. So, Deborah, last question. All right, if an employee tests positive, are we required to report this to our employees who have been in contact with them? And my answer to that is yes. You would be required to notify them in that instance, right? Because you would have an obligation to alert them to the harm. And if your employees out there don't know and they're out, right, they've been exposed now, they need to seek health treatment. And it would be the same if you knew there was a hazard that exists within your building and you did nothing about it. In this instance, your employees could be out infecting a whole host of other people. So yes, you do. All right, I know we're 10 minutes past. I think all of the questions have been answered, and I appreciate you all sticking through it with me. That being said, what I want to do though, and the questions can certainly be sent in to the AAA at info@ambulance.org. Certainly, you can also reach through the Gravity form, which is on the AAA's website, or you can reach out to me directly through any of those contact information. That being said, we will do this again. And what I would suggest for folks, please, please, please keep your suggestions or the issues that you're facing coming, because that's the way we know what to tackle next. That being said, new guidance. Thank you, Rob, CDC. We hopefully look to the Daily Digest tomorrow, or at the latest, well, we'll do it by tomorrow. Make sure that it gets out if it's anything of real consequence to folks. But with that, I want to thank you. Megan, I'm going to hand it back to you.
Awesome. Thank you so much, Scott. And thank you to everyone who joined us this afternoon, both on Zoom and on Facebook Live. Just as a reminder to everybody, the recording of today's webinar and also the PowerPoint slides will be posted to the AAA website on the on-demand webinars page, and that's under the education page on our home website. And I also added that to the chat box. But if you go to ambulance.org, you will be able to access that recording and the PowerPoint slides. And as Scott mentioned, if you have any questions for him or the AAA, you can email us anytime at info@ambulance.org. And with that, I'll go ahead and conclude today's webinar. I hope everyone has a great afternoon.